Oh. A lot of people interested in this.
SJC-11903, Joseph F. Frawley Jr., V., Police Commissioner of the City of Cambridge.
Just those things combined. But I don't know that we want to do something really broad about what dependency is.
Good morning, Mr. Aylesworth.
Good morning, Chief Justice and Associate Justices. May it please the Court. I represent the appellant Commissioner Robert C. Haas, who is the Commissioner of Police of the City of Cambridge. We're here today appealing a decision by Judge Wilkins of the Superior Court on Frawley's motion for summary judgment, which was granted over the opposition of the Commissioner. There are two issues that are presented for appeal here today. The first being that the Commissioner argues its position that the court erred as a matter of law in granting or finding that there was a cause of action based solely on an administrative regulation, absent any showing or evidence of legislative intent for there to be one here, under 501 CMR 1303.
So that depends, it doesn't have anything to do with facts in dispute. Let's assume that there were just no questions whatsoever about whether this gentleman were qualified. A qualified, what is the technical term? Qualified, retired?
Retired in good standing.
Retired in good standing. Let's say there's no question about that. You're saying that someone like the police commissioner could simply say, well, I don't feel like it. I don't, no matter what happened in the past, it just, too bad. I don't want to do it.
Well, I think you...
And there's no way to get relief in the face of that kind of intransigence?
I think that you're asking two separate questions there, Your Honor. I think what you're asking initially is, regardless of the facts, there is no cause of action here. I would agree with that statement here.
So that regardless of the facts, there's no cause of action here?
That's correct, Your
So
Honor.
that for any reason or no reason, the police commissioner could simply refuse to give the card?
Well, I think that the answer to that question kind of depends upon understanding the broader context, the purpose of the regulations and the statute as a whole.
Before you get that, could I just ask a factual question? I just want to make sure I've got the right background. In 2004, when Mr. Frawley retired, he got a retiree ID card, I think it was called, or something like that. Was the statute in effect at that time, the federal one?
No, it wasn't, Your Honor.
Okay, so what was the basis when Commissioner Watson gave Mr. Frawley that? What was where did that come from?
I don't know the answer to that question, Your Honor. There is no evidence in the factual record.
Well, but you presumably know what the department's policy was. I mean, I don't think this was made up out of whole cloth. Do you know anything about that?
I don't know the answer to that question, Your Honor. I think and I believe that these were issued just as when somebody retired, they were just given these cards. There was, as you say, the LEOSA was enacted, the federal statute was enacted in July of 2004. And so the state regulation, obviously, that the plaintiffs are attempting to invoke here was...
So we don't know on what basis. There was no Cambridge Police Department regulations or policies about issuing retiree ID cards before LEOSA. Is that...
That is correct. The policy that was enacted by the police department under Commissioner Haas was promulgated in July of 2011.
Had they issued retiree licenses before that date?
Yes, Your Honor.
For approximately what period of time, like 30, 40 years? Had they been doing it anyway?
I don't know the answer to that question. I can certainly supplement or...
Do you know if it was a subject of collective bargaining?
I'm not sure.
Getting a retiree ID license.
I'm sorry?
Getting a card. Getting a card upon retirement that would allow you to carry a weapon.
The card, well, that's two separate issues, Your Honor. The
Yeah.
card does not enable you to carry a.
Well, or that IDs you as whatever.
Right, yeah. So my understanding is it is not a matter of collective bargaining to.
Okay, but I mean, it's sort of it sounds like before this law was enacted, the retired police officer ID at least had certain beneficial fraternal purposes.
I think that what the retiree ID card was prior to LEOSA is that it was a representation made by the department that this person had previously been a police officer, no more, no less.
Now, if
We
there
have a-
were if there were a cause of action under the federal law, would you lose, at least as to that issue?
If there was a federal cause of action, well, that's a difficult question for me to answer because there is no, obviously, the courts have held that there is no federal
Well, you
cause
say the
of action.
courts. I gather there are two courts which have ruled on the issue.
There's more
that
than
clear?
two, actually, and the most recent court that ruled on this actually was in July of 2015, and I wanted to bring that decision to the court's attention. I also gave a copy of that decision to counsel before the hearing. I only recently came across it, but that is Dewberry, D-U-B-E-R-R-Y et al. Versus District of Columbia, and that's a June 26, 2015 decision.
Is that, I mean, because I think the Johnson case from New York, from New York, is very different than this. I mean, I take it that what that's dealing with is a policy of the state of New York that they are not going to issue the prerequisite for getting the what LEOSA would otherwise offer, right?
Well, I don't know that it's significantly different here. There, the retired correctional officers were attempting to have the federal court, in a declaratory judgment action as well, say that they were entitled to compel the state of New York to issue.
Right, but the difference is this state authorizes it. And so, right, we've got regulations and it says you can do this, and we've got a statute that the regulations go to. So this is really an individualized determination about whether this particular person is entitled to have it, isn't it?
Well, a couple of things to say in response to that, Your Honor. There is no statute that says that there is a right to this identification.
Not a right, but you've got regulations that are implementing
LEOSA, arguably.
right.
And so what the object of these regulations are to provide a standardized systems that these cards, I mean, you have to imagine what the purpose of LEOSA is to allow police officers from all across the country, from tens of thousands of different entities. All of them have their distinct, identification cards. Here, the regulations, the purposes here in Massachusetts is to comply with the directive of LEOSA to come up with a standardized set of cards, a certification that's placed on the back of the cards so that they don't have to sift through all of these cards to determine whether or not the officer who is attempting to carry a concealed firearm across state lines is somebody who is retired in good standing.
Can I stop you for a second there? I mean, so let me just understand how this works. You've got the regulation. The regulation was promulgated when?
I don't know the answer to the question,
Okay.
of that
And it was
question.
promulgated pursuant to the statute, which is 131R, which allows the Secretary of EOPS or his designee to promulgate regulations to carry out the purposes of this section. That section being licenses to carry firearms, conditions, and restrictions, right? That regulation was promulgated pursuant to that statute, right?
That statute, that section, yes.
Okay. And that,
But that statute says nothing about the issues.
but I thought you just said it was intended to implement
The federal
the federal
statute.
statute. Where do we have that?
That's essentially what, in the regulation itself.
The
I believe
regulation
it's-
itself says so.
It does.
Section 13.01.
Okay,
The
so
purpose-
regulation-
The purpose is to establish rules, regulations governing the standards for identification cards for retired law enforcement officers to comply with the provisions of the Federal Law Enforcement Officer Safety Act of 2004, 18 U.S.C.
Okay.
926.
So that's why we know that, so it's being promulgated pursuant to a law that has to do with licenses to carry firearms,
I would-
and is specifically there in order to implement the federal statute, which also deals with carrying firearms.
I would agree with the second statement, Your Honor, but I would respectfully disagree with the first, because there is nothing in Chapter 140, Section 130, that speaks about anything having to do with the issuance of retiree identification cards for the purposes of complying with LEOSA.
So do you think that the regulation was improvidently promulgated? Was there no authority to do this under that?
So ultra-virus or something like that? Ultra-virus? Ultra-virus, not virus. Ultra-virus.
I think that it was an attempt to, by the Executive Office of Public Safety, to adhere to the admonition or the prohibition in the United States versus New York, so that it could avoid any anti-commandeering arguments that may have arisen. I don't know, I can't, I'm not certain that I could say not necessarily that the regulation is ultra vires.
So is it your position that with the regulation in place, that number one, every police department can decide, A, whether to grant these kinds of cards or not, identification cards or not?
I agree.
That's what you say. And an officer can't do anything about that. And number two, and it's completely, Cambridge is one thing, Somerville may choose something else, doesn't matter. And that's unreviewable. And number two, even if that weren't true, on an individualized basis, you can, the commissioner can say, I don't want to give you one. That's it. Goodbye. And there's no review. That's what you think.
Well, Your Honor, I think that the commissioner retains discretion to determine.
But it's
who to-
unreviewable discretion.
I think that it's the burden of the plaintiff or whomever is seeking to try and review the decision of the issuing entity to be able to set forth a proper cause of action. There but the purposes of this appeal, they're attempting to say that they're attempting to enforce a regulation. They're attempting to press a cause of action upon an applied, there's in the absence of any express right in a statute or in the regulation. There may be other remedies that they could
Do we still
avail
have
themselves
mandamus
of.
do we still have mandamus in Massachusetts?
Your Honor, I know that in trying to formulate some sort of response to this question that's been posed by Justice Botsford, I was thinking that probably the answer to that question may be mandamus, but I am not certain on that.
Why? Because if it was mandamus, then your argument that discretion plays any role goes out the window, because you can only get a mandamus to have somebody do something that they have a duty to do.
Well, I don't have an answer to that question. All that I know is that what this court had said in Lafredo is that absent an express cause of action, the courts will not find an implied cause of action unless there is some evidence of legislative intent to create one.
Let me ask you this. Maybe somebody did ask you this, but does Cambridge, well, obviously the answer to my question is no, because now Commissioner Haas has adopted policy. So there are officers, retired officers in Cambridge who hold these identification cards, correct?
I believe so.
So it's just that this one isn't entitled to one. That's where you are.
That's correct.
Okay.
Now, the federal statute does not require any police department to issue these cards, does it?
It does not, Your Honor.
It just says that if they do, then they may carry a firearm.
Yes, in so many words, yes, Your Honor. I think that what it also requires is that they either demonstrate, there are two prongs to it. They have to get the photo identification, and then they also need to get certification from the state that they have received firearm training and are certified in that respect.
The term qualified law enforcement officer means, and it has certain requirements, but one of the requirements is that you have this card. I mean, you basically, without the card, you can't carry. I mean, you can carry, but not pursuant to the statute.
Well, you cannot carry across state lines
Right.
and take advantage of
So
the
this
benefit
card, and,
afforded by LEOSA, correct?
And I gather the federal courts have said that this is not, that the purpose is not to protect the public, the purpose is, or not to, I'm sorry, the purpose is not for any right of a retired officer. The purpose in general is to enable retired officers who are to essentially be able to help out when they cross state lines?
I think that my understanding of the purpose of the law was originally passed was in order that the retired officers or other officers could protect themselves. That was my understanding of what the purpose of the law was when it was passed in 2004.
But protect themselves, but they don't have a right to receive it, according to
That's
federal law.
correct, yes. And the Johnson Court talks very specifically about this, that just because they may be afforded private, and they may actually have a right, doesn't necessarily mean that the courts will recognize a remedy to redeem that right.
Does the, do the identification cards that are issued by the chief, do they make the statements that are, I believe, required by federal law for purposes of the law, that he's been found to be qualified for active law enforcement status? Do the IDs cards say that?
My understanding, in the record, there is the policy that the commissioner has, and then that language, I believe, is placed on the back side of the card. It's important to note that when this card was originally issued to Mr. Frawley back in 2004, at the time of his retirement, it didn't contain that. So that card would not have served his purposes under LEOSA if he wanted to take advantage of his rights there.
Okay, and these cards have to be issued, in order to comply with the federal law, they have to be issued at least every year?
I don't know the answer to that question, Your Honor.
Okay.
Okay, thank you.
Thank you, Your Honor.
Mr. Chief Justice, Associate Justices, may it please the Court, I'm James Lamond, and I represent the appellee, the plaintiff, retired Cambridge Police Sergeant Joseph Frawley. To start off, we believe that the Superior Court judge ably navigated a very complex and multifaceted dispute, one of first impression, but we believe he applied the principles that are applicable. If I may start off with a question that was just posed, one of the many complicating factors in this overall thicket is what do I need to have per my state's regulatory scheme in order to have this benefit, this immunity that comes to me under federal law. Your Honor, the retiree ID card is a one-time deal. It's a one-shot deal.
What do you say about the language in the statute that says not less recently than 1 year before the date the individual is carrying the concealed firearm?
So that's the second card, Your Honor. I need two cards to get this protection. The first card, my admission ticket to my training qualification, is my retiree ID card, which I get from my former employer. Then every 12 months, I need to go to a state-certified LEOSA instructor to demonstrate that I retain the competency to wield the weapon that I wish to take across state lines.
So if Cambridge, I shouldn't interrupt you, go ahead.
Well, no, Your Honor. So it may be that the fact record here lacks certain pieces of information that the court ultimately determines to be dispositive. Among them, what was the state of affairs before Massachusetts waded into the LEOSA thicket? And
When did those, do you know when the EOPS promulgated those?
We believe they're from 2008, Your Honor. They have since been revised to account for a change in the federal law, which expanded the universe of eligible former employees from retirees to those who separate. That's a change in the federal law, and the regulation was adopted, was amended to reflect that change.
So if Cambridge says, we are just not going to issue these cards, period, and you go to federal court and you say, my client is being denied the benefits of 18 U.S.C. Section 926C by the refusal of the Cambridge police chief to issue the card, the ID card that I need in order to obtain my rights under 926C, do you have a cause of action?
Your Honor, if I'm in federal court asking a judge to declare that 926C gives me that right, I probably lose. If I'm in federal court For whatever reason, I think I probably would be in state court. But if I'm in state court saying, under my state regulatory scheme, I'm entitled to this set of cards, then I don't lose. And I'd like to discuss
But
why.
it's a state regulatory scheme that is designed only to implement the federal law.
So the reason why the courts have said individuals can't go into the federal court system and ask for a declaration that their state employer, their public employer has wrongfully not given them a card, the reason why the federal courts have said that has everything to do with the fact that Congress has passed a law that affords an immunity, a benefit to a defined class of people. But it has acted in a topic area that is traditionally left to the states to regulate licensing of firearms. So Congress made a decided effort to say, when you get this set of cards from your state-regulated system, then you will get the benefit of this federal benefit. The federal courts are dismissing those cases because, in effect, and the case that has just been cited to you says it perfectly in the final paragraph. If you've got a beef with the failure, the refusal to issue a card, that is one that you have to process under the state regulatory scheme. And that's exactly what the federal court judge in the most recent case did.
But with respect to Chief Justice Gantz's questions, if Cambridge said, forget this case, just said, nobody, we're just not doing this. We are not issuing cards to retired officers. Could they do that? I mean, could you challenge that if they did that?
I don't believe any municipality now would be free to do that after the state regulatory agency has promulgated regulations commanding that certain action be taken.
Where's the authority of the state regulatory agency to do that?
Yeah.
There's no statute that says they must.
So the order of events, as it has played out historically, has been Congress passes LEOSA and leaves it to the states whether they wish to participate. States are free to opt in by acting in some fashion, and they're free to sit on the sidelines and therefore not extend these things that an officer would need to get federal protection.
Chris, so does it come under the Home Rule Amendment? Is it, are they specific? I mean,
So
where do they get the authority to do it?
At least the way the agency has set forth when they've, in asserting the authority under which it acted, it cites Chapter 140, Section 131R, the regulation promulgating authority under the state firearm statute. So at least the agency believes it was acting under the wide grant of authority that the legislature gave it as the authority that regulates licensing of firearms when it chose to act. Now, other states, Nevada, for instance, they've passed laws that look like our LEOSA reg. Massachusetts, for whatever reason, has not passed a law to do that, but the regulating agency, citing statutory authority, has stepped in to do that.
Could a city or town pass an ordinance or a bylaw authorizing the chief to do this, to do that?
The Congress's concern was that the person who crosses state lines with a concealed weapon has the state law-based right in the state that they're leaving from to have done so. They have left it to the states, presumably a state statute, but perhaps in our case, a regulatory agency, to set up the vehicle, the mechanism to do that, to achieve that status.
But the chief of police doesn't get authority to act by virtue of congressional pronouncement. He depends, doesn't he have to rely on state authority?
I believe the answer to that question, Your Honor, is if the regulatory agency here has not acted, but Cambridge or any other city said, it would be a good idea for us to participate in LEOSA, we want to put up a regulation of our own that allows for the issuance of this ID, I wouldn't have a high level of confidence as the officer crossing state lines that I have achieved the LEOSA prerequisite for my immunity, because it's an individual departmental determination as opposed to what Congress seemed to have in mind, which was the state law regulation of this topic, should the states choose to weigh in and afford this status.
So, with respect to the question of whether Cambridge could choose not to, in some kind of blanket policy, we don't have to get there because Cambridge has chosen to grant these licenses.
I believe that's true, Your Honor. And
So-
to your I'm sorry. To your earlier question, I don't believe that Cambridge would be free to set a higher bar than what the regulating state agency has set by way of what must be demonstrated by the retired officer, and that is the good standing measuring stick.
But the federal, the state regulation, as is true of the federal law, doesn't define what retired in good standing means.
On the issue of what is the measuring stick and what do we mean by good standing, we do believe that that Congress has given us a measuring stick. And
Well, I know you do. You say it's in 926B.
correct, Your Honor.
But one might say that the fact that Congress chose not to put the language of 926B in 926C suggests that it didn't intend to.
That is certainly a one reading from the statute. Perhaps the other reading is that since we're talking about a retiree or someone who's separated, it is no longer relevant to talk about whether they have the requisite 926B law enforcement powers. But we can safely say that the status that Congress wanted that individual to have, if Congress were the one regulating who gets the cards, the status that Congress wanted that person to have was someone with intact law enforcement powers at the moment that mattered. For an onboard person seeking the 926B protection, that status is, I've got authority to exercise law enforcement powers. For the retiree who no longer has that status, the question really is, in our view, at that moment, when you retired, is that an accurate description of your status? Did you have active law enforcement powers? Because once I'm retired, there's no other measuring stick of my entitlement. And Congress.
Let me ask you this. If we say that, basically your challenge is to the individual determination that was made here, not to give your client the replacement
That's
card.
correct, Your Honor.
So if the issuance of an identification card under the Cambridge identification card program, and actually under the EOPS regs, is basically looking at the individual, why wouldn't this maybe be a certiorari action under 249.4 and not declaratory judgment?
Your Honor, we thought that the recent decision involving the Pacheco law, SEIU, set forth what appeared to be the appropriate framework for how to proceed.
But that wasn't right? That was sort of saying, how do you challenge? It seems very different to me.
In our view, it had all the relevant characteristics. It was a regulated entity declining to do something that.
But there was a statute.
There's no doubt it's a statute, Your Honor, and if it turns out that it's statute versus reg is the dispositive distinguishing characteristic, then my argument doesn't fly. But if it does not matter for purposes of assessing where do I go to challenge the noncompliance by that regulated actor, in our view it doesn't matter because the declaratory judgment statute captures regulatory enactments as well as statutory enactments.
Is there any other purpose for this card other than to use it to get this ability to carry across state lines?
Your Honor,
Is it
for
worth
regulatory
anything?
purposes, it appears to be the entry, the ticket into the qualifications training by the LEOSA instructor.
And there's no other benefit that's conferred by the presence of this card?
Your Honor, there's no other benefit that the regulation contemplates, whether there are other sorts of things that come from having the card, I don't know, but I don't think it was within the reach of the regulators to take those into account. It was simply, you need that card to get the training, every 12-month training that will allow you to ultimately get this federally protected status.
Let me ask you a question. Did the card that your client had that got broken did not have the endorsement on the back of it that the regulation says is necessary?
Your Honor,
Was he still able to get the training and do whatever in order to be able to carry a gun across state lines?
So, Your Honor, the record doesn't contain evidence on either of those 2 points.
Okay.
And as far as prior efforts to get the training. The record is silent on that as well, and in our view, it's not a consideration that ultimately bears on, does he now have the right, in the wake of the 2012 denial of the ID card, for some access, some pathway into the court system for review of that decision. And on that score, Your Honors, I wanted to take a few moments to talk about why the Lofredo case doesn't set an insurmountable bar to persons like my client. In our view, the interesting question in Lofredo would have been, and you'll recall that in Lofredo, the individual wanted into a particular hospital. The hospital denied him for a reason that a regulation said was an impermissible reason to deny admission. That individual, rather than going to the regulatory agency and complaining that this regulated entity had denied him access, instead brought a lawsuit seeking an order to be let into the facility, but seeking monetary damages. And out of Lofredo comes the question that if the only basis that you as that individual has to be in court is a regulation, that's not going to cut it, and there's an explanation of why that suggests an overreaching by the executive branch where there wasn't clear guidance from the legislative branch. The question that would have been helpful in Lofredo is, what if that individual had said, I don't want money damages, I simply want an order to be in court? What is the vehicle or the pathway for me to do so? If the question had been, does 231A give the court equitable authority to hear my claim, then we would have had some guidance from the court as to whether it doesn't matter what your pathway is, what your vehicle. There hasn't yet been a determination that Chapter 231A and its reference to regulations, the ability of a court to declare rights and responsibilities as to regulations, there hasn't yet been a ruling that says that don't come to us for enforcement of a regulation under that pathway. And I don't think that that would have been the outcome in Lofredo had that been framed that way.
231A is pretty clear that it doesn't create a cause of action itself.
231A does not create standing. In our view, 231A does create the cause of action. And here's where I believe cause of action, right of action, has become confused over the years. Our U.S. Supreme Court has noted the confusion that those terms engender. As a practitioner, I think of, is there a pathway? Has the legislature enacted a pathway for me to the courtroom door? And in our view, 231A is such a pathway. It doesn't mean I have standing. They may have created a pathway for people in my shoes, but I still need to show through traditional means, through the SEIU measure, I need to show that I've got the standing, and that's the measurement of, have you created a duty? Is there a right that it seems to pertain to me? Am I in that smaller class of people who can seek to enforce that regulation as opposed to just the general public? If there are no other questions?
Yeah,
I'll
I've got
rest
one
on-
more.
Oh,
With
yes, sir.
regard to, if you have this card, do you need a license to carry in Massachusetts?
Your Honor, my understanding from my reading of the regulations is that the right to carry comes from having demonstrated the capacity. I'm either an onboard police officer and I have that right, or I have demonstrated my qualifications under the LEOSA regulation, and that is my permission to carry the weapon.
So once you have this card, you have permission to carry a firearm in Massachusetts or elsewhere?
Yes, Your Honor.
And even if the police chief says, I'm concerned about domestic violence with regard to you, the police officer has no power to remove the gun?
I don't know that the regulations look at the question of the police chief's authority to disable a granted permission or license. The regulations, as I see them, don't speak to that, but there is the general regulatory legislative authority under 140, Section 131, that regulates the respective rights and responsibilities of police chiefs and license holders.
So does your client have a regular license, forget this, a regular license to carry?
The record is silent on that question, Your Honor. I don't believe he does, but I don't also believe that it relates or matters to
I understand you say it doesn't matter, I just...
In other words, he is waiting for the outcome of this proceeding to see where he stands relative to LEOSA.
All right, thank you.
Thank you very much, Your Honor.